Hello, and welcome to the New York Medical Group Management webinar. My name is Erin, and I'll be your host. We would like to thank today's webinar sponsor, Barclay Damon LLP. Today's presentation is led by Maggie Soroka. Maggie is the former general counsel at the New York State Dental Association with over 20 years of legal experience. She's currently with Barclay Damon. Maggie primarily concentrates her practice on representing individual healthcare providers and facilities in licensure, disciplinary, and ethics proceedings. She routinely counsels clients facing Medicaid, Medicare, and other governmental investigations and audits, as well as assisting with employment and contract matters. She assists clients with compliance programs and has successfully represented healthcare entities with significant disclosures to the federal and state government. Maggie also defends clients facing license revocation and represents them in disciplinary matters before the Office of Professional Medical Conduct and the Office of Professional Discipline. Maggie additionally represents employers from other industries and matters before the New York State Division of Human Rights. Her familiarity with the New York State and New York City lobbying laws helps her navigate clients' lobbying, compliance issues, and audits. We're very happy to have Barclay Damon's support and Maggie with us today. Please welcome her.
Hi, everyone. And first of all, I just want to thank you all. We are in extraordinary times. This is extraordinary in that I am sitting in my dining room giving this presentation, and I will apologize ahead of time if my dog in any way barks. You will hear her. She has a piercing bark. So I hope that won't happen. I want to get right into this. I have a large number of slides, but what I want to do today is really go through a lot of the flurry of regulations, guidance, and other things that's been coming out in rapid, succession. It's every day we get something new. And I'm going to go through really the kind of things you should be aware of and let you know how this could affect your medical practice. I'm going to assume that most people on the phone and on the call are, in fact, a medical practice. And some of the things that we'll talk about, there are actually exemptions for medical practices and healthcare providers here. I'll go over that as well. But I'd like to go through everything that's really been passed that could affect any employer and anyone dealing in the midst of this pandemic. We are operating in a crisis. And, one of the things that I know with healthcare providers is they're very good at being calm and operating in a crisis, but even this is extraordinary. Just last night, the CDC came out with additional guidelines for healthcare workers returning to work. So we are getting different guidance every single solitary day. So what I will do is point out some of the things that you should always be aware of. And what I have in my handout that I know you're going to be getting next week are some links as well. You should always be checking CMS, CDC, and New York State DOH as well for additional guidelines. One thing that I have noticed in this environment is the government has really stepped up to try to help everybody out in guiding them with all the different regulations that are coming down the pike. So what I'm going to go over today is we're going to talk about some of just the regulatory changes, some of the executive orders and things like that that are affecting medical practices. We're also going to talk about the sick leave, both the federal and New York State sick leave, how they intersect and how they might apply to your practice or how you may be exempt from those. And we're also going to talk about the CARES Act. And the CARES Act has many provisions. Not only does it have provisions that your practice may be dealing with, but it also has provisions that could allow you some financial options. One of the things we're all seeing in this environment is just a uncertainty as to economics and business planning. And so there are some financial options that may be available to practices, and we'll go through that as well. Obviously, we are on pause in New York State. And although most people are on pause, since all of you are in healthcare, you are coping with the rest of the world being on pause and you providing your essential services. Obviously, Governor Cuomo, back on March 20th, which seems like forever ago, ordered that all New York State businesses will reduce in-person workforces by 100%. Obviously, the order to reduce the workplace exempted essential businesses. And as part of an essential business, we have any kind of healthcare operations. So the governor exempted essential businesses, including healthcare operations, from his order putting New York State on pause. But even essential businesses were ordered to at least look at the guidance to see what they could do and to maintain social distancing to the extent possible in their work environments. In addition, even in essential healthcare providers, the government has instructed that providers really try to utilize, to the extent possible, any telecommuting or work from home procedures for those staff that would be able to work from home and still provide services. Now, obviously, CMS has also come out with several guidelines for medical practices and how to deal with this pandemic, what to do in order to obviously conserve healthcare resources. And really, the guidelines talk about postponing non-essential surgeries and other procedures and encouraging all medical practices to implement telehealth and other procedures when at all possible. On this slide, I actually have the links to go into CMS where they talk about just certain guidelines for physicians, for medical practices, and others in terms of really prioritizing what needs to be done in the office and putting on hold non-essential procedures. As you know, dental offices and opticians and ophthalmologists were told right in the very beginning to put on hold any non-essential procedures, and most of those offices pretty much closed down almost right away. Both the ADA, New York State Dental Association, had advised that, but even other medical practices have been basically told to restructure, to look at their practices, to see what they could do to put off non-essential procedures. And so each one of the offices has really taken a look. They've looked to see, one, what can be postponed, and two, what they can do differently. And this has really, I think, been a huge change for the medical practices, and it's really required them to be flexible. The other thing it's done is really shown that the government has stepped in, I think, to be flexible as well in terms of what they will do to help practices in being, more remote. One of the things that has been done is Medicare has expanded services that would be reimbursed through telehealth. It has expanded so that services both to new and established patients would be covered. It also had indicated that providers can waive Medicare co-payments for telehealth services for beneficiaries in original Medicare. And it's added services that they will provide. I have a link right here to CMS, which goes over just some of the different telehealth options that are available under Medicare. The government has also acted in certain ways to relax HIPAA to a certain extent. HHS has said it will not impose penalties for noncompliance with regulatory requirements under the HIPAA rules against healthcare providers in connection with good faith provision of telehealth during COVID-19. And a covered healthcare provider that wants to use audio or video communication to provide telehealth to patients during the pandemic can use any non-public facing remote communication product to communicate with patients. The methods of communications that have been said to be acceptable, that is, they're non-public facing, include Apple FaceTime, Facebook Messenger video chat, Google Hangout video, and Skype. They have said that the following are not acceptable methods of communication, meaning that they're public facing. That would be Facebook Live, Twitch, and TikTok. And again, I have a link in the actual handout that you can press on that again talks about special topics, emergency preparedness for healthcare providers. Not only has the government come in to give recommendations and guidance, also our professional societies have also come out with guidance. The AMA has recommendations as well to medical practices. Some of the recommendations that they have put forth include making advance calls to patients, checking with them, checking them in remotely, reviewing and going through your cancellation and rescheduling policies to relax those to deal with obviously changes during this pandemic, advising patients to self-screen so that you're aware that it'd be safe for them to come into the office. And again, considering telemedicine whenever it would be possible. The AMA also said, go through things with your staff. Make sure you have a common script, a common language for all the staff to use when talking to patients and getting information to and from patients. And also the AMA recommends that prescribers increase prescription refills so that individuals will have a large enough supply on hand. The World Health Organization also has given guidance, and one of the things they've really stressed is healthcare workers' rights. And they have stressed that as a healthcare provider and as a medical office, you want to ensure that you have necessary PPE, and that has been obviously the most wanted piece, the most wanted supplies out there is the PPE. You want to make sure you have enough of it for your workers. Workers should not incur their own expenses for their own occupational safety and health requirements. That is something that is up to the employers. And there's been governmental guidance as well. OSHA and the EEOC have printed guidance that employers can look at or employees. One of the things we are seeing is that many employees are scared. They are looking on these websites. They are wondering what their rights are. And as you know, as healthcare providers, the employees are necessary. And so there has been relaxation in some of the requirements for healthcare providers. The U.S. Department of Labor has been putting out guidance about all the different labor laws that have been affected, the changes that have been made on a weekly basis. We just got new guidance again from the U.S. Department of Labor, and obviously the New York State Department of Health as well has been giving guidance. New York State has recently set forth their protocol for return to work. March 28th, the DOH came out with their updated protocols for personnel in healthcare or other direct care settings to return to work. And I'm going to go over this. And then I'm also going to point to the fact that we've got CDC guidance that came out just again yesterday. So providers and staff that have been exposed to confirmed or suspected cases of COVID-19, in order for them to return to work, they should self-monitor their temperature and symptoms twice a day. They should wear a face mask until 14 days after exposure. They should be assigned to patients at lower risk, and they should self-quarantine while not at work. If they are symptomatic at all, they must immediately stop working and isolate at home. These are the kind of things as a healthcare provider you are going to want to repeat and stress to your employees so they are very much aware of what the policies are and what the protocols are. Any staff with symptoms should be managed as if they have the infection itself. Staff with confirmed or suspected COVID-19, in order for them to return to work, they must maintain isolation for at least 7 days. They must be fever-free for at least 72 hours without taking fever-reducing medication, and they must have improvement in other symptoms. If they're asymptomatic, but they're tested and they are found positive, in order for them to return to work, they must maintain isolation for at least 7 days, must be fever-free for at least 72 hours, improve in other symptoms, wear a face mask, and again, be assigned lower risk patients if possible. You may have all heard the CDC actually came out with new guidelines yesterday. I actually saw it last night for essential workers to return to work. Their guidelines include that they must take their temperature before work. They must wear a face mask at all times. They must practice social distancing as work duties permit. They must stay at home if they become sick. They can't share headsets or objects used near the face, and they can't congregate in break rooms or other crowded places. What I'm seeing and what I'm hearing about too is that there are apps that are out there to help different employers in getting their employees to screen, to take their temperatures, and to report what their conditions are so that you're aware and you're also able to let them come back into work at the appropriate times. Best practices for all providers right now. Obviously, there's COVID testing. Hospital workers are prioritized, but obviously the hope would be that all healthcare providers would be able to get COVID testing on a priority basis also. One of the things that we are learning and one of the things that is stressful is that you have to be flexible every single day here and deal with situations. Symptoms arise, symptoms have to be dealt with for different staff all the time. And what we're hearing, especially depending on where you are in the state, is that many healthcare providers are just dealing with staff shortages. They're dealing with workers who are becoming symptomatic, who are testing positive. So you really have to work and be flexible in what you're doing and how you're providing for those patients that you do continue to serve who do have urgent needs. And so I also want to bring up the fact that furloughed employees who are unable to work because they have symptoms, they have tested positive, they may qualify for paid sick leave. That kind of gets me into the next series of laws that went into place, and New York quickly acted and enacted legislation to deal with paid sick leave. It was early on now, March 18th, when the New York State Legislature passed an updated version of a bill that would mandate paid sick leave to employees. And it included other protections for employees who had orders that affected their work because of COVID-19. Now, this bill actually is limited to a certain extent. It provides employee protections in the event of orders of quarantine. So it's more limited than what you might have heard with the federal legislation, which I'm going to talk about in a little bit. This legislation really has a very narrow scope and protection for employees. All employees are covered. So it includes employees that are part-time, per diem. It may even include contract employees. It is a very broad definition. The statutory leave and the benefits provided under this new law are available to employees who have been officially and formally quarantined or isolated by a state or local government agency. So in this regard, those employees that are entitled to the benefits do not include employees who are in voluntary quarantine or isolation. So for example, they traveled, and after traveling, they came home, they were advised to voluntarily quarantine or isolate. They do not fall under the coverage of the New York State Paid Sick Leave Act unless, again, a local government or a governmental agency has issued a quarantine order for them. Employees who merely fear they've been infected by the virus, they're not entitled to this protection either. Or employees who are objecting to report to work for fear of exposure to the virus, they're not covered. Employees who are placed on leave, layoff, or furloughed by an employer are also not covered by this. So if you did have to furlough employees, if you had to cut back on staff, they're not entitled to the benefits under the New York State Paid Sick Leave Act. It's only those employees who are, again, subject to a mandatory quarantine. Again, the law does not apply to those who self-quarantine or isolate, to those who are asymptomatic, who aren't yet diagnosed with any medical condition, and who are physically able to work remotely. The law also doesn't contemplate benefits for employees who are home caring for children due to a mandatory school closure as a result of the pandemic. Now, we have heard about the fact that there are benefits for individuals who are home taking care of kids who are home for school closing. That would be the federal law, which is much broader than the state law. And that is not what we're talking about here. I'll get into that a little bit later. These benefits and the benefits that employees are entitled to depend upon the number of employees that the employer has, the number of employees the practice has, and the amount of revenues of the individual employer. So employers with more than 100 employees as of January 1, 2020, those employees are entitled to at least 14 days of paid sick leave at their regular rate of pay. Employers with 11 or more employees, or employers with fewer than 10 as of January 1, whose income was greater than $1 million, are entitled to at least 5 sick days. And after those days are used, the employee may be eligible to receive weekly wages through a combination of paid family leave and disability benefits. So there's a combination that they could use. And then employers with fewer than 10 employees and whose income was $1 million or less, then those employees are eligible to receive weekly wages through a combination of paid family leave and disability benefits up to a maximum of $2,884.62 per week. For this New York State paid sick leave, again, it's very narrow for those that are entitled to the benefits. It's those that have mandatory quarantine orders. So what you are going to want, if you have an employee that comes to you with this, is you're going to want to make sure that you have the documentation from the employee that shows they're entitled to this benefit. And the documentation would include the mandatory isolation order that they have. It should say that the employee has tested positive for COVID-19, or that testing is currently unavailable to the employee, but the employee is symptomatic and has had a contact with a known COVID-19 case. The documentation should also include that they're subject to the mandatory quarantine and an attestation that the employee meets one or more of the following: that the employee's been in close contact with someone who's tested positive or is currently in a mandatory isolation, the employee is symptomatic and has returned within the past 14 days from a country designated with a level 2, 3, or 4 advisory for COVID-19. And the documentation from the employee's licensed medical provider must include, if the employee is subject to a precautionary quarantine, it should meet the following criteria: the employee is asymptomatic and was returned within the past 14 days from a country designated with a level 2, 3, or 4 advisory. The employee has been determined to have had proximate exposure with someone who's tested positive for COVID-19. And that would all be in an attestation that you receive from the employee. What we have seen is we've seen a number of these quarantine orders, and the local health departments that have been issuing these orders usually have been pretty good about answering questions. So if someone does come to you with an order, you're going to want to look at the order, you're going to want to get the documentation, and you're going to want to see exactly what they have and see if they qualify. There may be other qualifying events. We are seeing changes in what the state and federal government are putting forward. Keep in mind also that it really relates to your workforce. So if anyone's tested positive, run a search of the local quarantine orders to see if there is an order in place and if there's a trigger under the New York State sick leave. Under this new legislation, the government has decided that they want to make sure that individuals who take leave will obviously have their jobs protected when they're able to come back. So the biggest question is their job protected? Yes, it is. An employee's job is protected during the leave and is entitled to be restored to the same position they had prior to taking the leave. An employee cannot be fired because they took the leave. Any COVID-19 quarantine leave should not be counted as an absence that could lead to any kind of discipline, discharge, demotion, suspension, or any other adverse action. So if you have employees who qualify for the leave under New York State paid sick leave law, and again, it's very narrow, it's really those employees who have a quarantine order, they may be entitled to all the benefits that we've gone over, and the Department of Labor has guidance on their website about this too. And they're certainly entitled to be protected, to have their job back and not to be retaliated against for taking that leave. Now, the federal government has also stepped in. They have enacted the Family First Coronavirus Relief Act, FFCRA. You have probably heard a lot about this act. You've probably heard a lot about the benefits that it grants to employees under the act. I'm going to go through some of those, and we're going to go through them relatively quickly, again, on a kind of a high level here, just hitting on the high points. I will note that at the very end of this, the act actually exempts healthcare employers and providers. Most of you on this call, I assume, are going to qualify under that exemption. Therefore, you do not have to provide all these benefits. I know some of you might not qualify under that. I do want to go over again quickly what those benefits are. The act came into effect on April 1st. Contains two main components. It's the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. Under the Emergency Paid Sick Leave, employers with fewer than 500 employees, I can't take a poll, but I'm assuming that's probably most of you on this call, would be covered unless you are exempt. Meeting that 500 person threshold, the law goes into how you count your employees to meet that. Employers must provide paid sick leave to any employee who is unable to work or telework due to a qualifying need for leave. The reasons could be the employee's own condition, that they're subject to a quarantine or isolation order, that they've been advised by a healthcare provider to self-quarantine due to COVID-19 concerns, the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis, the employee is caring for an individual who is subject to a quarantine or isolation order or has been advised by a healthcare provider to self-quarantine due to COVID-19, or the employee is caring for a child whose school or place of care is closed and childcare is unavailable, again, due to COVID-19 precautions. With respect to this, the Department of Labor has said the child has to be under 14 and that the individual seeking this leave has to be the primary caregiver of that child. The employer may exclude employees who are healthcare providers or emergency responders from coverage. So on this call, I'm assuming that many of you will qualify for the exception, and therefore you are not obligated to provide the leave here. I'll go into that again. But again, it's a huge exception for healthcare providers or emergency responders, to which I believe most of you would apply. I'll go quickly. What the law does provide is for paid sick leave, 80 hours of paid sick time for full-time employees. For paid sick time, the individual would receive a maximum of $511 per day. For paid sick leave, if the person's caring for a child, the amount they would receive is less than that, 2/3 the rate of what they would receive if it's for their own condition. Employees are immediately eligible for the paid sick leave, and employers may not require employees to use other paid leave ahead of time. They can use their emergency paid sick leave first. The Emergency Paid Sick Leave Act ends on December 31st of this year. The U.S. Department of Labor has the authority to issue regulations, and they have been issuing guidance on this. They have been very good about putting their guidance up on their Department of Labor website, and that has been continuous, and they have been putting up frequently asked questions, trying to really get to most of the questions that employers have, the most common questions. What they've also just done is they provided a poster for employers to post. It is required that employers will post a notice of this new Emergency Paid Sick Leave Act. And I've included in here the link for the poster for employers to post. The Act includes anti-discrimination provisions and anti-retaliation provisions. Therefore, again, employers cannot take action against an individual who avails themselves of the benefits of this law. There are penalties for employers as well who violate the provisions of the Emergency Paid Sick Leave Act. And again, I'm going to end with this on the FFCRA. Healthcare providers are exempt. Both the paid sick leave and the expanded family and medical leave sections of the FFCRA state that an employer may elect to exclude healthcare providers and emergency responders from receiving the benefits under the law. Anyone employed at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare instruction, a medical school, local health department or agency, nursing facility, retirement facility, nursing home, home healthcare provider, or any other facility that provides laboratory or medical testing, pharmacy, or any similar institution is exempted from the terms of the federal law. So that was kind of an overview of everything, and then an understanding that most of you on this call probably fit into the exemption. That exemption is for the healthcare providers that I just went over. It also includes first responders. So if you would meet the definition of first responder, you also would be exempt under that law. What I'm going to go into now is just the provisions of the CARE Act that provides some financial aid options for employers. I didn't say at the beginning, but I know Erin had gone into my bio. I am in the healthcare and human services practice and the labor and employment practice of Barclay Damon. Our firm provides counsel to providers, and many other people in the firm are in our financial services department. And they've put together a lot of the slides that I will use here, and they're the individuals I would direct anyone to if you needed more information about the CARES Act financial aid options for employers. Again, on March 27th, the president did in fact sign the CARES Act into law that provides $2 trillion in aid for individuals, businesses, and other entities in the wake of COVID-19. The CARES Act provides different provisions based on the size of different employers. So you really need to look at how big your business entity is to find out what the provisions are that you may take advantage of. For mid-sized companies, the CARES Act includes a $500 billion authorization for the U.S. Department of Treasury to make loans, guarantees, and other investments to support eligible mid-sized businesses. This is the one that a lot of people have been talking about, and a lot of businesses are trying to see if they might be able to take advantage of these loans. With this general loan program, the Act emphasizes that the Department of Treasury Secretary should endeavor to make financing to banks and other lenders so that they can make direct loans available to mid-sized businesses. Mid-sized businesses are those between 500 and 10,000 employees. Under the terms of the loans are to have an interest rate not greater than 2%. With no payments of principal or interest for 6 months or longer. Obviously, this is all to help mid-sized businesses to kind of get through the financial stretch that we're in. Any entity wishing to take advantage of the loan program needs to make certain certifications about their economic viability. They must certify that the economic uncertainty requires the loan to support the ongoing operations of the company, that the funds will be used to retain at least 90% of the workforce at full compensation and benefits until September 30th of this year. The company needs to say that they intend to restore not less than 90% of the workforce that existed on February 1st, and to restore all compensation and benefits to workers not later than 4 months after the termination date of the public health emergency declared in response to COVID-19. And the company must certify that they will not outsource or offshore jobs for the term of the loan in 2 years thereafter. The entity must also certify that they will not abrogate any existing collective bargaining agreements for the term of the loan in 2 years after repayment. and that the company will remain neutral in any union organizing effort for the term of the loan. The CARES Act also has a provision that a lot of people have looked into and a lot of companies have looked into, which gives protection and loans for payroll. It's the Payroll Protection Program for small companies. The CARES Act allocated $350 billion to help small businesses keep workers employed during the downturn. This is known as the Paycheck Protection Program. The initiative provides a 100% federally guaranteed loan to small businesses who maintain their payroll and their employee headcount during the emergency. The loans would be forgiven if borrowers maintain their payrolls and or restore their payrolls and headcounts by June 30th, if in fact they've furloughed any employees now. You're eligible for the Payroll Protection Program if you're a small business with fewer than 500 employees. You otherwise meet the SBA's size standard. You can be a not-for-profit with fewer than 500 employees, or an individual who operates as a whole proprietor. You're also eligible if you operate as an independent contractor. You're an individual who's self-employed, who regularly carries on a trade or business, any tribal business concern, or a 501c19 veterans organization that meets the SBA size standard would also be eligible for the Payroll Protection Program. Lenders are going to be looking for eligibility, and they're directed to consider whether the borrower was in operation before February 15th and had employees for whom they paid salaries and payroll taxes. Lenders will require a good faith certification, like for the other mid-sized companies. The uncertainty of the current economic conditions make the loan necessary to support ongoing operations. The borrower will use the loan terms to retain workers and maintain payroll. The borrower doesn't have an application pending for a loan that's duplicative, and the borrower has not received duplicative loans. They'll require that the borrower has not sought or obtained credit elsewhere. A personal guarantee is not required for the loan, and no collateral is required for the loan. And the loans can be up to 2.5 times the borrower's average monthly payroll cost, not to exceed $10 million. Included in the payroll costs that can be included in this loan are salary, wages, including payment for vacation, sick leave, allowances for dismissal or separation, payments for group health care benefits, including insurance premiums. All those would be included in the payroll amounts for which an employer might be eligible to receive these loans. Excluded are a portion of compensation for any individual employee that's in excess of $100,000. That's their cash salary. Anything that's in excess of that would not be included and eligible for these loans. There is loan forgiveness in these loans. A borrower is eligible for loan forgiveness equal to the amount the borrower spent on the following items during the 8-week period beginning on the date of the origination of the loan. It's the payroll costs, interest on existing mortgage obligations, rent on existing leasing agreements, payments on utilities, and for borrowers with tipped employees, additional wages paid to those employees. And the loan from forgiveness cannot exceed the principal of the loan itself. The amount of the loan forgiveness calculated is reduced if there's a reduction of greater than 25% in the employee's headcount, or a reduction of greater than 25% in wages paid to employees. Again, the purpose of these loans are so that businesses can retain employees and retain their payroll. What if the employee brings back employees or restores wages? If they do, in fact, bring back employees and restore wages by June 30th, then those are considered in these amounts and they can receive loan forgiveness. In addition to these loans that are available, the Economic Injury Disaster Loan Program has also made loans that are available to businesses that they might be eligible to apply for. Eligible entities include small businesses, sole proprietorships, private not-for-profits, independent contractors, cooperatives, ESOPs, and tribal units that apply for loans in response to COVID-19. Again, these programs are all separate. So if you were to get a loan from one, you can't get a loan from another. But they're all options that might be available to you. And as you may know, and you may have already applied, many institutions are in fact awaiting their applications to see if they have been approved and whether these funds will be available to them. I'm going to go forward just a little bit and talk about the Employee Retention Credit, which also falls under the CARES Act. If an entity is not able to get one of the loans that I have talked about previously, there may be another option for them to get some relief if they actually keep on their employees. And that could be through the Employee Retention Credit in the CARES Act. The CARES Act includes this tax incentive for employers to keep employees on the payroll. The tax credit is up to 50% of qualified wages paid by eligible employers to employees during the COVID-19 crisis. The credit applies against the employer's share of FICA. And then there's a $10,000 per employee cap on this payroll credit. The IRS can either advance the tax credits to eligible employers, or it can waive the failure to pay to deposit the FICA for employers who anticipate receiving the credit. Any eligible employer includes an employer, even tax-exempt employers, whose operations have been fully or partially suspended as a result of a government order limiting commerce, travel, or group meetings, or that experienced a reduction of over 50% in quarterly receipts, and they count that towards the receipts from last year. So again, if you're unable to get some of the other loans that have been available through the other programs, you may still take advantage of, I'll call it your Plan B, this tax credit that you have for keeping employees on if you've had a reduction in your operations due to COVID-19 and the orders that have been issued as a result of them. The wages that qualify, again, they're going to count based on the size of the employer. So if you're an employer with over 100 full-time employees in 2019, it's just those wages that you're paying for those employees who are not performing services, who are furloughed, but they're remaining on the payroll. But if you're under 100 employees, the wages that qualify are all wages paid in 2019. And again, to coordinate with the other provisions that we've talked about, this employee retention credit does not qualify and does not include wages taken into account for purposes of mandatory paid leave credit. Also, retention, this tax retention credit is not available to employers who have a work opportunity credit, or if they have an FMLA credit under the IRS code 45S. So again, these programs are available, but they coordinate with other programs that are available. They're not going to allow you to double dip. They're not going to let you get tax credits from one if you're getting credit for different types of wages in another program. So you really need to coordinate. Other limitations is that obviously the employee tax credit's not available if you're receiving a small business loan, and it's not available for those that are receiving the Paycheck Protection Program. One other thing I wanted to point out is that if you have Medicare, there are some accelerated payments that are being available under the COVID-19. And to qualify for advance or accelerated payments under Medicare, the provider must have billed Medicare for claims within 180 days immediately prior to the date of the request. They must not be in bankruptcy. They must not be under an active medical review or program integrity investigation, and have no outstanding delinquent Medicare overpayments. If they're eligible, then 100% of the Medicare payment amount for a 3-month period can be accelerated. So 100% for a 6-month period. It includes inpatient acute care hospitals, children's hospitals, and certain cancer hospitals, and then 125% of the payment for a 6-month period for critical access hospitals. So those are the amounts that they can have accelerated. If approved, the MAC will issue payment within 7 days from the request, so you can get these payments ahead of time for Medicare. The provider can continue to submit claims as usual after issuing the accelerated or advanced payment, and the provider will receive full payments for their claims during the 120-day delay period. And the process is automatic. NGS is actually what, for New York State, will be assisting with this process, and we have a toll-free number that you can call if you want to find out a little more about the Medicare accelerated payments. One other thing I'll mention, there is pandemic unemployment that's available. This is something that's available to your employees, obviously. I wanted to just go over it. Employees do get some extra unemployment if, in fact, you lay them off. And what I've found from some employers is they realize that some employees would make more money if they're being laid off than if they kept them on and had to reduce their pay. Federal pandemic unemployment compensation includes an extra $600 a week for those that qualify, and it actually extends qualification for those employees that might not otherwise be eligible for unemployment benefits under traditional unemployment in the state. It includes waiving the first week of unemployment, and it also includes an additional 13 weeks of unemployment compensation. Again, these are all programs to help employees that have been laid off. The individual must be able to work, available to work, and actively seeking work. Again, it includes people who might not otherwise be eligible for unemployment traditionally. That would include independent contractors, those who are self-employed. Gig economy workers would also be entitled under this new unemployment law. And again, the workers would be eligible up to a maximum of 39 weeks of benefits, an extra $600 a week as well. And let's turn finally to liability issues. In the New York State budget that just recently passed, there was clearly an acknowledgement of protection needed for healthcare professionals and facilities that are dealing with COVID-19. In the New York State budget, healthcare facilities and professionals have been granted immunity from civil or criminal liability for any harm or damages alleged to have been sustained as a result of an act or omission for services that relate to the diagnosis, prevention, or treatment of COVID-19, the assessment or care of an individual with a confirmed or suspected case of COVID-19, or the care of any individual who presents for health services during the period of the COVID-19 emergency declaration. Requirements for this immunity. The provider is arranging for providing healthcare services pursuant to a COVID-19 emergency rule or otherwise in accordance with law. And the act or omission occurs in the course of arranging for or providing healthcare services and the treatment of the individual is impacted by the healthcare facilities or the healthcare professionals' decisions or activities in response to or as a result of COVID-19 outbreak and in support of the state's directives, and the healthcare services are provided in good faith. If you have those, you can receive immunity as long as the act or omission does not constitute willful or intentional criminal misconduct, gross negligence, reckless misconduct, or intentional infliction of harm. But it is a very good sign that in the New York State budget, there was this expression of immunity that should apply to most cases for healthcare providers that are providing services relating to COVID-19. Finally, and I want to leave room for a few minutes for some questions, I want to thank you all. You are all essential healthcare workers who are out there really on the front lines. You are reacting at warp speed to not only the changing circumstances in the community which you serve, but also changing circumstances in terms of the regulatory and legal framework that you're operating under. But we thank you. I thank you for even taking the hour. I know your time is incredibly precious right now. I went through things very, very quickly, and I'm really happy to take some questions now if I can.
Okay, here we go. Jim asks, what about Medicare Advantage programs?
What about Medicare Advantage? Does he want to know if they include the accelerated payments?
Maybe he'll give us a little more information. He then asked, what about pediatricians who don't see Medicare patients? Maybe he'll give us a little bit more information. Vernon asked about mandatory quarantines that include international governments like Canada, and how they would, how these laws might extend, or these, what you talked about, would extend to those employees, I would assume.
Yeah, and under the paid sick leave for New York State, it really is a New York State or a local, New York State issued quarantine order. And so we want to look at that. What I have seen, and some of the things I'm seeing, is if someone were to come in perhaps with a quarantine order from another country, another jurisdiction, I would have them call the local health department here in New York and see if New York then issues a quarantine order based on that. And so that's how I would deal with that. I would ask for more information from the employee.
Jim said yes, in answer to your question.
On the Medicare payments.
Yeah.
And what I will do, Jim, my email's here. I will look into that. I believe that does, it could qualify as long as it's Medicare. It would qualify, but if you want to email me, I can look and follow up for you. I don't want to give you the wrong information, and I can certainly point you in the right direction for that.
Dan asked about if you knew about the additional $30 billion that CMS has announced would go to healthcare providers with, quote, no strings attached.
I don't have a lot of information on that, and that's a good question. And thanks, Fran. We can look into that and we can provide that. I know that the attendees are going to be getting information next week, Erin. And what we can do is make sure we give that information as well.
Okay. Anchal asked, are the Medicare accelerated payments available to primary care practices? Please clarify if these are accelerated in advance payments or accelerated or advance payments.
They're accelerated payments. I think only accelerated payments, and it should be available to primary care providers. Yes.
Okay. And Keith asked, can value of pension expense, employer state taxes, and employer federal taxes be added to the calculation of gross payroll costs for the SBA PPP loan?
I would go back. I do not believe those are included in there. I think it's I will have to go back and look at that and make sure. I don't want to tell you the wrong thing. I do not believe they are, though. I believe it's straight salary compensation, not pension.
Okay. Would unemployment law cover staff that is furloughed instead of laid off?
If they're furloughed and they're getting paid, no. But if they're furloughed not getting paid, I'm wondering if that's the question. They might qualify under the employment. They may very well.
Okay. Are insurers who run Medicare Advantage programs supposed to also provide a Medicare Advanced Payment program?
Can you repeat that, Aaron?
Are the insurers who run Medicare Advantage programs supposed to also provide a Medicare Advanced Payment program?
I think it's all being done through NGS, not through the providers themselves. I would direct that question, and I'd have that provider specifically call NGS and ask that question. I have the number for NGS in the slideshow, and I would have them call specifically on that. But I think it's being done through NGS and not the actual insurer.
And we have two more, and then we will let everyone get back to their day jobs. I would also appreciate information on the mechanism to distribute the $30 billion available to mid-sized medical providers and not just hospitals.
We'll get you that information. Yeah, well,
okay.
That'll go with the 30 million. We'll try to get. I'll add some additional information on that, Aaron.
Okay. And then I filed for EIDL more than a week ago and haven't heard from them yet. Nothing about the $10,000 grant either. Any suggestions?
I've been hearing that from everybody, and I think we're all. I think everybody's waiting with bated breath. And I know I've been told that they're trying to process those as quickly as possible. I do anticipate that people will have an answer on that very soon.
Thank you very much. I want to thank all of you for joining us today, and thank everyone. Thank Maggie for taking the time to put this together so quickly.